Here are the crypto top headlines covered in this video. SEC deeply regrets errors related to crypto firm enforcement case. Next, global securities regulator says governments need to know who runs DeFi protocols. Also, Hong Kong's financial regulator opens door for spot crypto ETFs. Welcome to Crypto Top Headlines, where there's no clickbait thumbnails or titles, and no speeches on my opinions, just bringing crypto's news to you. We are a new channel here on YouTube, and would greatly appreciate it if you would click on the like and subscribe buttons, as well as the notification bell. It does help support the channel, so thank you in advance for doing so. Now, on to these headlines. Our first top headline: SEC deeply regrets errors related to crypto firm enforcement case. The Commission acknowledged it had not been accurate and candid in earlier filings, but said sanctions were not warranted as its staff didn't engage in any bad faith conduct. Lawyers representing the United States Securities and Exchange Commission have responded in court over claims they spun a false narrative to avoid dismissal of an enforcement case against a mining software firm. In December 21 filings in U.S. District Court for the District of Utah, Northern Division, the SEC said it had failed to be accurate and candid in earlier court filings, claiming software firm DebtBox closed certain bank accounts and planned to relocate to the United Arab Emirates in an alleged attempt to escape the Commission's jurisdiction. According to the filing, the SEC failed to correct a misrepresentation of facts presented to the court to secure a temporary restraining order to freeze assets. The Commission takes this court's concerns seriously and deeply regrets these errors, said the SEC. Agency officials are taking steps to ensure those errors are not repeated in this action or other proceedings. In a separate declaration, SEC Enforcement Director Gurbir Grewal apologized on behalf of the Commission, acknowledging it had fallen short of standards to present accurate evidence to the court. He said the Enforcement Division would have additional training starting in January 2024. The case stemmed from a July lawsuit filed by the SEC, which alleged that DebtBox perpetrated an illegal $50 million crypto scheme. The court granted the SEC a temporary restraining order to freeze the company's assets in August. However, it reversed its decision in November after determining that the Commission represented evidence regarding DebtBox's bank accounts and intentions to move to the UAE. Judge Robert Shelby, overseeing the SEC's case against DebtBox, suggested the Commission could face sanctions due to its inaccurate statements. According to the SEC, sanctions were not warranted as its staff didn't engage in any bad faith conduct. The Commission's representatives failed to accurately characterize the basis for their factual assertions, failed to identify inferences as such as to explain the basis for those inferences, and failed to identify inaccuracies in those assertions once discovered. On December 4th, lawyers for DebtBox filed a motion to dismiss, saying the SEC made false allegations in earlier filings and failed to meet the basic pleading standards for the case. The case has drawn attention from many in the crypto space, including representatives of firms facing enforcement action by the SEC. In most cases, the SEC's admission wouldn't be such a big deal because the other party would argue the other side, said Ripple Chief Technology Officer David Schwartz in a December 22nd X reply. But here, this was an ex-parte emergency proceeding, with the SEC asking for immediate, extraordinary relief, giving no opportunity for the other side to be heard. The SEC admission and the claims from DebtBox were a seemingly rare rebuke by a court as the Commission pursues multiple enforcement cases. The Commission has civil cases pending against Terraform Labs, Binance, Coinbase, Ripple, Kraken, and others. Our next top headline, Global Securities Regulator says governments need to know who runs DeFi protocols. DeFi's anti-centralized body nature makes regulating the industry a challenge, IOSCO said in its latest report, so governments should start by identifying the responsible persons. The International Organization of Securities Commissions, or IOSCO, published its Decentralized Finance, or DeFi, policy recommendations this week, and it's advising jurisdictions to figure out who is behind the so-called leaderless protocols. DeFi's anti-centralized body nature makes regulating the industry a challenge, IOSCO said in its latest report, so identifying responsible persons is essential. A regulator should aim to identify the persons and entities of a purported DeFi arrangement that could be subject to its applicable regulatory framework, the report read. These responsible person or persons include those exercising control or sufficient influence over a financial product offered, financial service provided, or financial activity engaged in, or over products, services, and activities that behave like or have been substituted by investors for financial products, services, and activities by the DeFi arrangement. The recommendation hints at an issue some crypto companies and users have already raised in the U.S., where DeFi operations have, in the opinion of some, been unfairly treated like individuals. In their lawsuit against the U.S. Treasury Department, Secretary Janet Yellen, the Office of Foreign Asset Control, or OFAC, and OFAC Director Andrea Gacki, blockchain users have alleged that crypto mixer Tornado Cash is simply a piece of computer code and therefore cannot qualify as a foreign national or person. IOSCO also suggests that members create laws that prevent conflicts of interest and market manipulation. Many DeFi arrangements and activities today are being conducted in a manner that presents conflicts of interest, the report states. DeFi participants may be acting in roles and capacities that create conflicts of interest. The DeFi proposal comes about a month after the Standards Organization unveiled its crypto markets regulation recommendations. This policy guidance, which came after a months-long consultation period, suggests regulations should focus on main points of risk in crypto markets, namely market abuse, client asset protection, and disclosure requirements. IOSCO, whose members represent around 130 jurisdictions globally, releases policy recommendations in an attempt to coordinate how nations respond to new technologies. Consistent regulation is necessary, the agency wrote in its crypto report, in order to reduce regulatory arbitrage. Vastly different crypto laws around the globe also reduce the ability of jurisdictions to enforce their laws, and depending on the laws of particular jurisdictions, potentially raise the prospect of jurisdictional borders hindering the effectiveness of the authorization and supervision process, the report added. IOSCO recommends that regulators and, when needed, lawmakers share information across borders in order to cut down on criminal activity and potential risks. Our next top headline, Hong Kong's financial regulator opens door for spot crypto ETFs. Hong Kong's Securities and Futures Commission said cryptocurrency transactions conducted by ETFs must occur through SFC-licensed crypto platforms or authorized financial institutions. Hong Kong is getting ready to welcome spot crypto ETFs as its financial regulator announced on December 22nd, that it's prepared to receive their applications. In a collaborative announcement today, the Securities and Futures Commission, or SFC, and the Hong Kong Monetary Authority, the city's de facto central bank, stated that both organizations have reviewed their current policy for intermediaries involved in virtual asset-related activities. The SFC expressed readiness to receive applications for the authorization of various funds, including virtual asset spot exchange traded funds, or VA spot ETFs, alongside the existing crypto futures ETFs. In another circular issued on December 22nd, the SFC outlines the criteria for funds to directly invest in identical spot virtual asset, or VA, tokens available to the Hong Kong public on SFC-licensed virtual asset trading platforms, or VATPs. The SFC emphasized that cryptocurrency transactions conducted by these ETFs must occur through SFC-licensed crypto platforms or authorized financial institutions. The regulator added that in-kind and in-cash subscriptions and redemption are permissible for SFC-authorized spot virtual asset VA ETFs. Regarding custody, the SFC specified that the fund's trustee or custodian should only delegate its crypto custody function to an SFC-licensed virtual asset trading platform or those meeting the crypto custody standards set by the HKMA. For spot virtual asset valuation, the fund's management companies should adopt an indexing approach based on VA trade volume across major VA trading platforms, the regulator added. Funds planning to have crypto exposure exceeding 10% of their net asset value must undergo prior consultation with the SFC, the circular stated. In contrast to the widespread crackdown on cryptocurrency activities in mainland China, Hong Kong has been receptive to crypto firms this year, actively encouraging collaboration with banks. In October 2022, Hong Kong issued policy statements on cryptocurrencies to enhance its status as a global financial hub. In June, the city initiated its crypto licensing system for virtual asset trading platforms, enabling licensed exchanges to provide retail trading services. So this concludes our top headlines. If you haven't already done so, don't forget to click on the like and subscribe buttons, as well as the notification bell. Also, leave your thoughts in the comments and share this video with your friends and family. Thank you all for watching Crypto Top Headlines, bringing crypto's news to you.